Hi, this is Luke with the Sandpoint Podcast, your source for information for all things North Idaho, the good, the bad, and the county commissioners. All right, today we're diving into a spicy little ordinance passed on March 25th, 2025, one that might just make you wonder if the county took a lunch break from democracy. This one's about the moratorium on minor land divisions and family exemptions. Yep, just a few little changes, like nuking the sections of the county code and forgetting how due process works. Let's take a look. Number one, evidence. Never heard of it. The county says the moratorium was necessary because, get this, inadequate infrastructure, wildfire risks, drainage issues. Scary stuff, right? The only problem is they presented zero evidence. No findings of facts, no conclusions, no reports, not even a blurry screenshot of a puddle or a smoky tree. All right. Well, let's not forget issues like fire access and drainage are already reviewed through the building location permit process. That includes input from the fire districts, from Panhandle Health, stormwater management. So either the county forgot how its own permitting process works, or they just really wanted to play SimCity with people's property rights. All right, number two, imminent peril or imminent power grab. Here's the big deal for justification. They leaned on Idaho Code 67-6523, which allows a temporary moratorium if there's imminent peril to public health or safety. This is something Commissioner Korn hit on several times. And Bill Wilson, the county legal advisor, tried to justify it. And he was very iffy about it when he said things like, health safety. That's not going to cut it. You cited nothing. You gave no legal findings of fact, you gave no conclusions of law, and you gave no examples of these issues that were so eminent. All right. So this is just, if this was such an emergency, they wouldn't have done it the way they did this. Number three, regular meeting for an emergency. Let's talk about the meeting where this was passed, because if this truly was an emergency, you would expect a special meeting with the appropriate notice and process under Idaho Code 74-204. But nope, they did not do that during a special meeting. They did this during a regular meeting, a regular business meeting. No special notice, no emergency declaration, no explanation beyond trust us. It's serious in, health and safety. All right. That's like calling 911 and the dispatcher says, we'll get back to you during normal business hours. Moving on to number four, temporary moratorium with the side of code deletion. All right, now here's the kicker. This wasn't just a pause on approvals. This ordinance eliminated the entire sections of county code like 12-611. They're gone now, 12-612, and all of subchapter 6.6. That's not a moratorium. That's legislative amnesia. And they did this without going through the standard amendment process, which means no transparency, no public input, and no real debate. Just a quiet little nuke of your property rights. Number five, posting problems, aka the oops, we forgot the law clause. According to Idaho Code 31-715, ordinances of a general nature have to be published in a newspaper and posted in 5 public places before they take effect. It didn't do that. I had my land use professional call the county and they still denied me being able to put in a MLD for my property split that was in process. Now, according to county code, they have to publish and post in 5 public places before this ordinance can take effect. So the county claimed that it took effect immediately. It was an immediate moratorium. I disagree. But as a time of adoption, it hadn't been published or posted anywhere. They went and recorded it, but it wasn't legal. It was finally published in the Daily Bee, but still no record of the 5 public postings. So technically, the ordinance didn't really exist until that publication date and those posting dates. That means that land applications denied before that publication may have been denied under a ghost ordinance. All right, number 6, legal challenges incoming. Let's recap. No real evidence of danger, no special meeting, code sections eliminated like expired coupons, no proper public posting. Put that all together and what you get is a very shaky legal foundation. Property owners who were denied because of this might have a real shot at challenging in court, and they will. And I wouldn't be surprised when they do. And when they win, I will be happy because that's the way it should happen. All right, let's wrap up. So what's the moral of the story here? If you're a county commissioner and you want to restrict land use rights in Bonner County, maybe, just maybe, try following the law. It's not that hard. Don't create fake emergency issues. There's a literal checklist that you guys can go through and do things legally, just like we have to do when we want to create an MLD or create a subdivision or do things like that. We have to have due process, proper public posting. We have to have public comment. You need to do that. But when you rush things through like this without evidence, skip proper procedures, and call something an emergency when it's clearly not, and you schedule it like a car oil change, it doesn't look like responsible governance. It looks like backroom deals right in the public's face. That's it for this week on the Sandpoint Podcast. I'm Luke Webster, keeping an eye on all things North Idaho so you don't have to read 14 pages of county code over your coffee. Don't forget to subscribe, hit the like button, tell a friend, and most importantly, stay informed. See you next time.